Tinubu to Tribunal. Nullifying presidential election on account of 25% FCT votes could lead to chaos, anarchy. President Bola Tinubu has warned that nullifying the February 25th election that produced him as president on account of the fact that he did not score 25% of the lawful votes cast during the election in the Federal Capital Territory (FCT) could lead to absurdity, chaos, anarchy, and alteration of the very intention of the legislature. Besides, Tinubu told the presidential election petition court, the Prepare, that the two petitions filed by the candidate of the Labour Party, Mr. Peter Obi, and his counterpart of the People's Democratic Party, Alhaji Atiku Abubakar, seeking the nullification of his victory at the February 25th presidential election, are not only novel, but not familiar with the country's electoral laws. Tinubu's submission were contained in his final written address against the two petitions pending at the Prepare. The five-member panel had on July 5th given the respondents in the two separate petitions 10 days to file their written address, while the petitioners were given 7 days to reply. The panel, led by Justice Aruna Tessimani, gave the order shortly after Tinubu, Shettima, and the All Progressive Congress (APC) closed their defense in the two petitions, as it would be recalled that the Independent National Electoral Commission had closed its case a day earlier. Both Atiku and Obi, alongside their respective parties, had dragged INEC before the Prepare for declaring Tinubu and the APC winner of the presidential election. Amongst the relief they seek is the nullification of Tinubu's election on the grounds that INEC did not substantially comply with the guidelines and regulations for the conduct of the 2023 general elections and relevant electoral laws. INEC's chairman, Professor Mahmood Yakubu, had on March 1st returned Tinubu as the winner of the February 25th election with 8,794,726 votes, while Atiku Abubakar and Peter Obi of were said to have scored 6,984,520 votes and 6,101,533 votes, respectively. Besides faulting the figures, which they claim were incorrect because the collation of results was still ongoing when Mahmoud returned Tinubu as the winner, the petitioners also claimed that Tinubu cannot be said to have won the election, having not scored 25% of the lawful vote cast in the Federal Capital Territory. Besides, the two petitioners argued that Tinubu ought not to be on the ballot because of an alleged United States District Court judgment that ordered the forfeiture of $460,000 suspected to be proceeds of drug trafficking. Another ground they are seeking is disqualification regarding the alleged double nomination of Shettima, who according to them was already a senatorial candidate for the APC in the Borno Central Senatorial District election conducted the same day and time with the presidential polls. While Atiku, before closing his petition, called 27 witnesses, including INEC's presiding officers and experts. Obi, on the other hand, called in 13 and tendered the electoral documents, including 18,000 blood result sheets on which INEC based the declaration of Tinubu as the winner. Although INEC, Tinubu, and the APC had interrogated the validity of the witnesses and documents to the petitions and asked the court to discontinence them. However, Tinubu, Shettima, and the APC, in the individual written final address, have asked the court to dismiss the two petitions because the grounds upon which they are built are not familiar with the country's electoral laws. The petition in issue in this address is very novel in the sense that it is not a petition stricto sensu, familiar to our electoral jurisprudence, as the petitioners are not this time around complaining about election rigging, ballot box snatching, ballot box stuffing, violence, thuggery, vote buying, voters' intimidation, disenfranchisement, interference from the military or the police, and such other electoral vices. The cruise of their growth this time around is that while the presidential election was peacefully conducted all over the country, as corroborated by their primary witnesses, and the results accurately recorded in the various Form EC8As, some unidentified results were not uploaded electronically to the INEC Election Result Viewing Portal (IREV). The other remote contention of the petitioners is that the second respondent did not score 25% or 1/4 of the vote recorded in the Federal Capital Territory, Abuja. While the petitioners have also alluded to the respondent's no qualification without any facts known to law, Chief Wole Olanipekun, SAN, counsel to Tinubu, had pointed out in the final address dated July 14th. Both Atiku and Obi claimed INEC breached Section 134 of the Constitution when it announced Tinubu, who did not score up to 25% of vote cast in the FCT, in line with the law. Section 134 2. Subsection B of the Constitution provides that a candidate for an election to the office of the President shall be deemed to have been duly elected where there been more than two candidates for the election. A. He has the highest numbers of votes cast at the election, and B. He has not less than one quarter of the vote cast at the election, each of at least two-thirds of all the states in the Federation and the Federal Capital Territory, Abuja. According to the INEC results, Tinubu was only able to garner 90% of the vote in the FCT. He, however, argued that it was erroneous for the petitioners to call for the nullification of the entire election based on the FCT result. While we have premised this issue on the combined reading of Section 134 and 299 of the Constitution and Section 66 of the Electoral Act, in the course of our argument, it is apt to submit right from get-go that election is about votes and voters, and when vote and voters are mentioned in any part of the word, there is no superiority of votes or voters, as all votes and voters are equal, adding that there is no superiority between the votes from voters secured in either Lagos or Kano, which are the most populous states, and Bayelsa, Ebonyi and Ekiti, which are the least populous states. Olanipekun further argued that while Section 3, Subsection 1 of the Constitution specifically lists the 36 states by their respective names, the side note reads thus: States of the Federation and the Federal Capital Territory, Abuja. Section 299, for ease of reference and clarity, provides thus: the provision of this Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation. The phrase "as if" has been defined in Corpus Juris Secundum, page 298, as connoting in the same manner and to the same extent. May we draw the attention of the court to the fact that there is no punctuation, comma, in the entire section of 134(2), subsection B of the Constitution, particularly immediately after the state and the succeeding and connecting the Federal Capital Territory with the states. In essence, the reading of the subsection has to be conjunctive and not disjunctive, as the Constitution clearly makes it so. Pressed further by this constitutional imperative, the Federal Capital Territory Abuja is taken as if it is a 37th state, under and by virtue of Section 299 of the Constitution. With much respect, any other interpretation different from this will lead to absurdity, chaos, anarchy, and alteration of the very intention of the legislature. Our courts have always adopted the purposeful approach to the interpretation of our Constitution, as exemplified in a host of decisions, including but not limited to Nafio Rabio vs. State 1980, 12 NCC 291 at 300-301, Mawa vs. Nyanko 2012, 6 NWLR .1296, 199-3062-307, ADH Limited vs. AT Limited 2006, 10 NWLR .986, 365-649, Awolowo vs. Shagari Supra, Ibrahim Adesina vs. President, Federal Republic of Nigeria 1981. 12 NSCC 146 at 167-168, AG Abia vs. AG Federation 2002, 6 NWLR .763-265 at 365. End of quote. The petitioners themselves admitted this much in paragraph 107 of their petition, where they listed the FCT as a 37th state after listing the states mentioned in Section 3. Subsection 1 is number 1 to 36. Again, the Maxi Respia Loquitus applies to the petitioners. Coincidentally, these sections of the Constitution were considered by the Supreme Court in the celebrated case of Buhari vs. Obasanjo 2005, 13 NWLR .941, 1 at 105, and the Apex Court held thus. This provision appears clear to me, where a candidate wins the highest number of votes cast in at least two-thirds of the 36 states in the Federation and the Federal Capital Territory Abuja is deemed to be elected. I do appreciate any ambiguity in the provision, and if there was one, this court is bound to adopt a construction which is just reasonable and sensible. See Maxwell on Interpretation of Statuses, 12th edition, chapter 10. In my view, it will lead to absurdity and manifest injustice to nullify the election for the entire nation because of the nullification of the election of one state, some local government areas, wards, and units. Such a devastating result could hardly have been contemplated by the framers of the Constitution. It is my conclusion, therefore, that the cancellation of the election in Ogun State and the other smaller components does not substantially affect the election of the first and second respondent. In the event this petition fails and same is dismissed with costs which are assessed at 5,000 naira in favor of each set of respondents. The senior lawyer submitted that from the Apex Court's judgment above, it could be seen that if results of elections are cancelled in more than one state, including the FCT, that election is not rendered invalid provided the winning candidate meets the constitutional requirement of 1/4 of the vote cast in 2/3 of the 37 states contemplated. Anything to the contrary would be devastating, and such was never contemplated by the framers of the Constitution. All the winning candidate needs is a majority of the votes, and even if there was no election in one state, including the FCT, or even if the election of a state or states, including the FCT, is or avoided, the entire election cannot be voided or cancelled. In concluding our argument on this issue, we urge the court to hold that any election where the electorate exercise a plebiscite, there is neither a royal ballot nor royal voter, and that residents of the FCT do not have any special voting right over residents of any state of the Federation. In a manner similar to the concept of preferential shareholding in company law, we urge this court to resolve this issue again the petitioner and in favor of the respondent, he pleaded. Faulting the entire petition, Olanigbeku urged that, based on the arguments and submission contained in this address, the court should dismiss this petition as totally lacking in merit, substance, and bona fide. It has been glaringly showed and demonstrated by the presentation of the petition itself and the evidence presented by the petitioners, including the evidence of PW27, that the petition itself is not only frivolous but also amounts to a crass abuse of the process of the court. Non-existent documents were being sourced and printed from the internet, among others, to be presented before this court after the filing of the petition, in furtherance of the abusive nature of the petition itself. According to him, it was glaringly evident that the election went very peacefully under a free and fair atmosphere, without proving cause of violence, ballot box snatching, and such other electoral irregularities and vices, a state of affairs to which the petitioner's witnesses all testified. In fact, the election was conducted in substantial compliance with the principles of the Electoral Act, the INEC regulations, and manuals for the election. The unchallenged evidence on record, particularly the sole witness called by the respondent, is that the first petitioner has bidded unsuccessfully for the office of the President of Nigeria severally, even till 2019, on the controversial issue of electronic transmission of results using the Bimodal Verification Accreditation System, BVAS. Olanigbeku said, coincidentally, a host of witnesses called by the petitioners corroborated the unstable and unpredictable nature of technological devices and applications within the Nigerian terrain, as this would be a demonstrated annul. The senior lawyer pointed out that it was wrong for the petitioners to build their case only on electronic transmission, as the law also recognizes manual transmission. Our clear submission is that all the provisions of the regulations created the alternative between electronic transmission and transfer with the use of article, or for instance, paragraph 38(1), which deals with movement from polling unit states, that on completion of all the polling units voting and result procedures, the presiding officer shall, when electronically transmit or transfer the results of the polling unit direct to the collation system as prescribed by the Commission. Tinubu, while faulting the evidence of the 40 witnesses called by both Atiku and Obi, claimed their testimonies rather complemented the case of the respondents. The evidence of these witnesses essentially centered around the functions of the BVAS and IREV, and ultimately seek to impeach the veracity of INEC's explanation about the technological glitches that occurred on the day of the election and its implication on the overall result of the election. Without equivocation, it is our respective submission that the petitioners have woefully failed in this adventure of theirs, and this will be seen through the direct analysis of their respective evidence. The evidence of PW2 is largely irrelevant for the benefit of the petition, as his witness statements on oath only attempted to align the various features and functions of the BVAS, the involvement of the Amazon Web Service and its corporate profile, as well as the description of the IREF, its working and configurations. However, despite the supposed authoritative assertion of this witness in respect of the BVAS and the IRF, under cross-examination, he confessed that he is not familiar with the applications on the BVAS device, and that as a software engineer, he has never designed any software that was applied for the conduct of any general election. Though this witness had made several assertions in respect of the AWS in his witness statement, in all fairness to him, he opened up that he is not a staff of AWS. Similarly, the witness confessed that he was not aware of the number of software that makes the components that INEC used for the 2023 general election, as he is not an INEC staff, admitting that he never had any of the materials he used for his supposed findings before the court, but on his laptop, which was not made available to the court. The irony about this witness is that despite his bogus claim and the bravado exhibited in the statement regarding the various technological issues, he eventually claimed not to be aware of anything at the end of everything. On the alleged US forfeiture proceedings, Olanipekun argued that the witnesses of the petitioners failed to point to a single mention of the word fine in any of the documents forming part of the proceedings tendered as exhibits, which they admitted had not been registered in Nigeria, in line with the clear provisions of Section 3 of the Reciprocal Enforcement of Foreign Judgment Ordinance and Foreign Judgment Reciprocal Enforcement Act. Without prejudice to the foregoing, it is our submission that there is no admissible evidence before this court that will make it void or set aside the election of the second respondent. May we submit straight away that the petitioners have not produced any evidence before this court to warrant voiding or setting aside the respondent's election. While the petitioners called 27 witnesses, it is our submission that substantially the cumulative effect of the 10th evidence provided by them is against the petitioners. We further draw the attention of the court to the fact that most of the witnesses came to rehearse the evidence of others before them. In essence, the end result of their evidence is the alleged non-transmission of already collated and entered results on Form EC8A to IRF Portal. We adopt our argument under Issue 1 insofar as they relate to the evidence of witnesses and are appropriate for this issue, while we have already raised and argued preliminary objections to the petitions itself. It is our further submission that every criminal allegation contained in the petition has not been proved, assuming without conceding that petitioners have not abandoned them. Starting from PW1, Captain Joe Agada retired, through to PW27, each of them admitted the correctness of the polling unit result. The law strikes that polling unit results constitute the foundation of an election. A successful challenge to the accuracy of a polling unit result is a condition precedent to the challenge of transmission of such result, whether to the world level, local government level, state level, or national level, whether manually or electronically. Right from old case of Uwombodo vs. Ono, 1984, 15 NSCC 127, the Supreme Court has held that election issues end at the polling booths where results are recorded in FEDECO forms, now Form EC8A, and that even if any issue arises, those forms and the result therein can be added. In the words of the Supreme Court, polling stations are the concrete foundation on which the pyramid of an election process is built, but the law and statutes on this position have not changed, whether with the introduction of BVAS or transmission to IREF. With much respect to the petitioners, one would have expected them to have a rethink on proceeding further with this petition after the delivery of the decision of the Supreme Court in Oyetola vs. Adeleke Supra, a decision which covers the field and clinically considered all issues which the petitioners are now agitating before this honorable court, including their failure not only to tender but identify or attempt to examine through any of their experts or witnesses any of the BVAS machines deployed by INEC in the course of the election. In the same judgment, the Supreme Court stated that the use of voters' register has not been discarded under the new dispensation. In this connection, most of the witnesses called by the petitioners, and indeed all the POS, testified to the proper, seamless, and effective use of the voters' register as well as the BVAS machine. Meanwhile, Tinubu has urged the people to add the sum of 10,929 votes in Kano State belonging to him but were discounted during the process of coalition, stating that if that was done, it will increase its votes from 8,794,766 to 8,800,369. In paragraph 83 of the respondent's reply, it has been pleaded that the vote scored by him in Kano State was discounted by 10,929. Exhibits RO820 and RO821 were tendered before this court, and the sole witness called by the respondent was made to speak to them, identifying the figures relevant to the pleading as appearing in column 9 of each of the exhibits. That is, a vote recorded in RO820 in bracket form EC8D was discounted by 10,929 in exhibit RO821 form EC8D subsection A. It was a mere arithmetical error which is apparent on the two exhibits. Thus, the court has the power and jurisdiction to add the discounted figure of 10,929 to the final vote of 8,794,726 recorded for the respondent to make his vote come to a total of 8,800,369 in conformity with Exhibit ROA 20 and ROA 21. We urge the court to so hold, he said.